You're watching once again a YouTube video presentation of the University of Wyoming Center on Aging. I'm Scott Veach. I'm your host, and on this program we'll be discussing topics of interest for caregivers of loved ones with dementia. We hope that you will subscribe to the channel and you'll hit that thumbs up like button. Both of those actions help the channel to grow and allow us to reach more people. And if you'll tap that notification bell, you'll be alerted each time we upload a new program. And now, this is Once Again. My guest today is Nancy Norton. She is with Norton Law in Jackson, Wyoming. She specializes in estate planning and elder law. And if you're with us for our discussion topics on Wyoming Dementia Together a couple of months ago, she was actually there with a two-parter. And so we're going to cover some of that information today. And we're so glad to have her with us. Thank you, Nancy. Thanks for being here. We want to first mention, as we always do when we touch legal matters, that this is not to be considered as legal advice. We want to make sure that everyone understands that and that we offer this up as some suggestions and some direction. But as far as the specifics go, it's always wise to contact legal assistance in your area, your particular state. How did that sound? Is that a pretty good disclaimer?
Perfect.
All right. Let's start off with the basics here, and particularly for those people who are caring for loved ones. And I guess we're talking about family members there. What is legal planning?
Well, legal planning actually encompasses a lot. Traditionally, people think of legal planning with respect to their estate. And so a lot of people are familiar with wills, even though many people don't have them. As many people as you would think, but it really encompasses what can happen during your life. And I would argue this is just as important as having a will. So for example, a power of attorney for finances and a power of attorney for healthcare, two really critical documents for everybody over 18, in addition to a will or a trust. And those are the primary documents that folks should have in place, no matter what age, really.
Is it ever too late to start?
Never too late to start. No, I see all kinds of situations in my practice. Some people who have children are really concerned about making sure their children have a guardian nominated. That's really important. And then most of my clients are probably in their 50s and 60s, thinking about retirement. But because we know accidents and injuries can happen and nobody can predict what happens in life, it's never too late to start. But if you start earlier, that is better.
You mentioned two kinds, power of attorney and power of attorney for healthcare. What's the difference?
Yeah, good question. So power of attorney for finances allows a person to grant authority to an agent to carry out their wishes if they're not able to do so because of illness or incapacity. And then similarly, a healthcare power of attorney would be a person granting authority to somebody, their agent, to make medical decisions if they're not able to do so themselves because of incapacity or illness or some other issue.
Right. And as far as the power of attorney is concerned, you talked about the decisions that can be made. Are there degrees of power of attorney, or when you set one up, are you just signing away everything?
Well, typically they're drafted very broadly, so the agent has a lot of authority to do certain things on behalf of the person giving the authority, but they can be tailored to somebody's situation, so they can be narrowed. It can include just a narrow range of authority, but typically they're drafted very broadly because you can't anticipate every single situation. So most people want to give the most authority they're able to give to their agent to be able to help them if they're not able to make their own decisions.
What kind of decisions are we talking about?
Yeah, good question. So on the financial side, we're talking about handling somebody's bank account, paying credit cards, making investments. If the person has a business, they may want somebody to step in while if they're not able to manage their business, or even sell their business if that's what the person who's giving the authority wants to do. And it can even range to things like cryptocurrency, managing that, digital assets. Um, so there's quite a lot of things. And it also gets into, in some instances, making legal decisions too. For example, filing for bankruptcy.
And when we talk about power of attorney, having gone through this myself with my wife, it doesn't have to be a terribly involved process. It sounds, I think, a lot more daunting than what it is or what it has to be. Is that right?
Yeah, it definitely does. I would recommend that people not do this themselves, even though it's not highly complicated. Every state has different rules about setting up a power of attorney, whether it's for finances or healthcare. So seeking the assistance of an attorney, I would strongly recommend, just to be sure you get it right.
And as far as caring for someone who has dementia, does there ever reach a point where that person really can't make that decision to sign the document, or it has the mental capacity to know what they're entering into?
Yeah, I'm glad you mentioned that, Scott, because you can only make these documents if you have legal capacity. And that's basically having an understanding of what you're signing, and knowing um, what you have and what authority you want to give to somebody, and being able to articulate that and give a reason behind it. So if somebody does not have capacity, they cannot make these legal documents that are so helpful. Now, having said that, um, just because somebody has memory issues doesn't mean they don't have legal capacity. And so it really is a detailed evaluation to make sure that somebody doesn't have the capacity, but there's a presumption that people do have capacity. And
Yes.
so you really have to look at some of the deficits that are happening, and you also have to look at it in the context of a specific a specific act. And so it's not just that somebody's a little forgetful a certain time of the day. It's capacity, as we know, can fluctuate during the day, can
Mhm.
fluctuate over weeks and months. And so that would be another reason why consulting with an attorney, if there are memory issues, is highly recommended.
My guest is Nancy Norton. She is with the Norton Law Office in Jackson, Wyoming. She specializes in estate planning and elder care. We talked about power of attorney. What about power of attorney for healthcare? How does that differ?
Yeah, so the focus of a power of attorney for healthcare is really on the medical and healthcare side of things. So um, a lot of states make that separation. They don't just have one power of attorney, they have a separate one for medical and healthcare reasons. So if you're a person that became incapacitated, you would want to have somebody on your behalf, an advocate for you, to deal with whatever medical situation has arisen, and also deal with your medical providers. And this agent should know basically what the person who's giving the authority wants for their health care. So it does two important things. It allows somebody to pick an agent or an advocate for them. And it also um, is a document that would detail the medical treatment somebody wants to have. And then as an offshoot to that, there's something called a living will. And a living will is really for end of life type care. And it's the terminology is a little confusing because it uses the word will, and it's not a will in the traditional sense of a last will and testament, but it's really what type of medical treatment you would not want at the end of your life if you knew you were going to pass away, say within 6 months. It gives you the chance to say, I want comfort measures only, and I don't want aggressive medical care to keep me alive.
And the medical community is well versed in power of attorney for healthcare, right? I mean, everyone is familiar with it, I would think.
Yeah, I think definitely people are very familiar with it. And then there are other ancillary documents that, for example, a pulse document. In Wyoming, we have a
Mhm.
WYO pulse document where that's similar, but it's really a medical directive. It's a medical document signed by the doctor and the patient. So the patient would speak with their physician about medical care if they were in an accident or they were severely injured. And so that's a little separate, but they're related and they should sync up. There shouldn't hopefully be a huge discrepancy between the healthcare power of attorney and the post.
So it's not something that the caregiver is going to have to school the medical community on.
I would not think so.
Right.
No,
Okay.
these are very, very common, typical documents. As a matter of fact, if you go to the hospital and you're going to have surgery, the hospital may ask you if you have this document, and if
That's
you
right.
don't, they may request that you sign it. And most of them have to be either witnessed or notarized, one or the other.
There is so much to cover in so little time. Our guest is Nancy Norton with the Norton Law Office in Jackson, Wyoming. We have covered power of attorney for healthcare, and we still need to get to some common barriers to planning, incapacity, things like that. And we will do that in part 2, which is coming up probably in about 2 weeks after this one posts. And so we will continue our discussion at that time with part 2. You've been watching once again a YouTube video presentation of the University of Wyoming Center on Aging. We hope, if you haven't done so already, that you'll subscribe to the channel and hit that thumbs up like button. Both of those actions help the channel to grow and allow us to reach more people. And if you'll tap that notification bell, you'll be alerted each time we upload a new video. Thanks so much for being with us. I'm Scott Veach. We'll see you again next time.